And welcome to episode 80 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Joanna Baron, the CCF's executive director. Our colleague Christine is away today. In today's episode, I'll tell you about a new proposed citizenship law on a Saskatchewan First Nation that would kick people out of the nation on grounds of quote unquote maturity and character, trouble, community dysfunction, unrest, or any other consideration.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to walk you through a decision that rejected a claim from an Ontario family who lost their teenage son after he got the COVID-19 vaccine. So Sean Hartman was a teenager in Ontario who got the Pfizer shot on August 25th, 2021. And this allegedly led to his death on September 27th, 2021. And there are no details in the decision about how the vaccine led to his death, but it is well known and was relatively well known back then that these vaccines can cause myocarditis and pericarditis, which are serious conditions where either the heart muscle or the muscles around the heart swell up. And the risk of myocarditis and pericarditis is much higher after the vaccine in young people, and in particular young males. So right in this particular demographic. So Hartman received this shot in what I personally think was one of the most shameful periods of Canadian history, which is late 2021. And that was a period where the vast majority of vulnerable people who needed the vaccine had already been vaccinated voluntarily without being forced by anyone to do that. But this was a period where suddenly the government decided that it would force everyone, including healthy young teenagers like Hartman, to get the vaccine through mandates and passports. Prime Minister Trudeau famously said earlier in 2021 that we're not the kind of country that forces vaccines on people, but when he saw this potential wedge issue in the summer of 2021, he decided to go for it and use it to browbeat the opposition. So, the story makes me mad because teenagers should have had a choice about whether to get vaccinated, especially considering that the vaccine didn't stop transmission. And like I said, in rare cases, had these potentially life-threatening side effects. And listeners will know that we sued the BC government over their absurd vaccine passport that didn't allow for exemptions, even for people like healthy teenagers who had had a reaction to the first dose. But anyway, this lawsuit in particular was a claim against the federal government under Section 61 of the Family Law Act. And the Family Law Act is one of the only ways you can sue for financial losses after you lose a loved one. You can get damages in some cases for things like loss of care and companionship if the government was negligent. And here the family's argument was pretty simple. They argued that Health Canada failed to follow its own rules about properly assessing, approving, and monitoring the vaccine for safety and efficacy, and that it was negligent and reckless about communicating about that safety and efficacy. And they say Health Canada induced Mr. Hartman to take the vaccine, and this resulted in his death. In particular, they're talking about things like news releases, health minister's statements, the prime minister's statements, advertising. They say that the government knew that this was a risky vaccine for people under 40. And they didn't say this in any of their public statements. So the government, for its part, argued that this is actually one of those cases that can be struck on preliminary grounds under a Rule 21 motion, because it discloses no reasonable cause of action, which is to say that it's plain and obvious, even if the facts are taken to be true, that this claim could not succeed. And they made that argument based on previous case law. And the judge agreed with the government. They said, based on this prior case law, this case can't go to trial. We're throwing it out at this stage. So the case was dismissed for the same reasons that most cases get dismissed when people try to sue our government over its failing healthcare system, even where there's what appears to most of us to be obvious negligence. And basically the court finds that there's no duty of care owed between the government and the patients, or owed by the government to the patients. And they say that even if there is a sort of prima facie duty of care, the court's not going to interfere anyway because these cases are about the design of the system as a whole, and those are core policy decisions which the court won't get into and won't hold the government accountable for. Just as an aside, what we're talking about here is a tort. So we're not talking about a constitutional case like the Canby case, but as listeners probably know by now, the government also found that, the courts also found that the government can harm people with their negligent healthcare system, and that doesn't somehow violate your rights. Unless it's something like a safe injection site or trying to ban drugs in public or trying to ban prostitution, in which case the court will somehow always manage to find a right has been violated. So anyway, I'm going to walk through this decision, and this is not just for my law nerds. I think a lot of people are interested in knowing why it's so hard to sue the government over these types of things. To establish negligence, and Joanna, I got a C in torts, so this is a little bit traumatic for me to even talk about this tort stuff, but to show negligence, you have to establish that the defendants owed the plaintiff a duty of care, the defendant's behavior breached the standard of care, the plaintiff sustained damage, and the damage was caused by the defendant's breach. And in this case, and indeed all of these healthcare cases where people sue for negligence, the court finds no duty of care. So to find that this duty of care exists, the courts apply something called the Ans-Cooper test, which asks, do the circumstances disclose reasonably foreseeable harm and sufficient proximity to establish a prima facie duty of care? And then, if that is established, are there residual policy considerations that may negate imposing the duty? Things like, worrying that you're opening the floodgates to all these claims that the government won't be able to pay, stuff like that. So the court here said there's previous case law that shows that there's just no duty of care in these types of cases. And one of the cases the judge looked at had very similar facts. It's a case from 2009 called Adam. And what happened there was the public health establishment decided children should all be vaccinated against H1N1, which is a pretty nasty flu. And this led to some deaths and also some pretty devastating side effects that the media more or less swept aside. And I hope nobody will call me an anti-vaxxer here. I'm not. I'm pro-vaccine. And, if you haven't had measles shots or you haven't given those to your children, now would be the time because there's a big measles outbreak and measles is very dangerous. But anyway, in Adam, basically the same thing happened that happened to Hartman. The government encouraged vaccination even though it was pretty risky for kids, and a child ended up dying and his family wanted to be compensated for that. The court there found that because the child didn't belong to, quote, a discrete or identifiable group, and that this was a core policy decision, the court couldn't award damages. So basically, in the rare cases where duty of care is found in these situations, it's because there is sufficient proximity between the government and the patient, in the sense that the government made specific representations to a particular patient or to a discrete and identifiable segment of the community or group, so that there's this more direct link or direct contact between the state and the person who died. For example, one of the cases where proximity was found, which is quite unusual, is called Heaslip Estate. And this was a case where the court refused to dismiss a claim that Ontario was negligent for failing to provide air ambulance transport after a person's death. And this was because there was a specific interaction where the state decided they were going to send the land ambulance instead, which was negligent potentially. And so this proximity was established and they could find the duty of care. So about the core policy decision thing. So the court has here found that this is a core policy decision, and they repeated a line from a Supreme Court case called Imperial Tobacco. And it says that government decisions that represent a course or principle of action based on balancing economic, social, and political considerations will be a core policy, and people can't sue. That would be a separation of powers issue. And the argument here is, we don't want government to be chilled from taking actions they need to take because they'd be worried about all these future lawsuits and it would open them up to all this liability. So my understanding of this decision in Hartman is that, the decision to approve the vaccine rapidly and then not warn the public necessarily properly was part of a core policy decision. So it seems like even in cases like this one where you think the government might have been negligent, the courts are just not going to find that that duty was even owed. So, Joanna, it's a really sad thing to think about. A 17-year-old boy is dead, possibly because of the vaccine. Certainly, the vaccine was pushed on people this age. Um, but do you think, in general, that courts are getting this stuff right? That they're right to be concerned about, core policy decisions, or are these decisions more of a cop out?
So I think it's a cop out. I remember I also struggled in torts, and I remember when this issue came up that you could have all of the hallmarks of a duty of care, which itself is a little bit challenging to confront as a one out, but then policy considerations could negate it, and policy considerations can stand in for virtually anything. But here, I think it is a clear case where I think a more analytically defensible response would be that, of course, there is a duty of care. Of course, people like this teenager and everybody else who is going to be receiving these vaccines were reasonably foreseeable to be affected by Health Canada's decisions at the same time. And I know this is it's heartbreaking for me, and I'm sure a lot of our listeners will disagree with this, but of course, there's core policy decisions why you don't want to open up the floodgates to litigation because, of course, Health Canada has to make decisions on a population-wide basis. And you could make the argument. I don't know if I remember when I looked at this at the time, not that I was a man under age 30, but I remember just out of interest, the risk of pericarditis, it wasn't like a huge risk, but it was like if you stack together the risk of pericarditis, if you were a young man compared to your risk of serious adverse consequences getting COVID, to me, they looked like it was like kind of a wash. And I understand how these are just like complex and nuanced things that are very hard to explain to the public. And Health Canada, and let's be honest, like most public health departments, made the decision to just kind of go with like a dumbed down, simple message, pretty much like everybody get the vaccine unless your doctor tells you specifically that you shouldn't or you have like certain limited conditions. Um, and that's just the type of thing that I just don't think courts have the capacity, the expertise, the information, the eyeballs to go in and interfere with. So all of which is to say, TLDR, I think there are policy rationales here why we don't want to open up the floodgates of tort law. Although tort damages are much more limited in Canada than they are in the U.S., where I'm not sure. Have there been cases like this in the U.S. that you've heard about?
I'm not sure. I would imagine there probably are. I don't know.
But there can't have been ones that were like massively
We would have
successful.
heard about it,
Yeah,
right?
we would have heard
Yeah,
of them. So
yeah.
even the US courts must be nervous about this, and the US is a famously litigation mania country. So. All right, well, let's go on to a new case that raises a lot of interesting issues and is also a bit of a follow-on to a case that we talked about last year that we participated in at the Supreme Court. This is a case from Saskatchewan concerning Saskatchewan's Canoe Lake Cree First Nation. And federal judges have approved, at least preliminarily, a landmark test case, which is examining whether individual members of the Canoe Lake First Nation can have recourse to the charter. So here's some background. In 2023, Canoe Lake members narrowly, 200 to 86, ratified a citizenship law that had several restrictive provisions. First, it limited membership to status Indians living in the community. Second, it denied membership based on assessments of quote unquote maturity and character. It considered an applicant for citizenship's history of trouble, community dysfunction, or unrest. It eliminated automatic membership for adopted children. It restricted individuals with juvenile delinquency records, and it allows for revocation of membership for quote unquote failing to learn the First Nations customs, traditions, values, heritage, and history. And recently, the Federal Court of Appeal directed a new hearing on the case after a lower court had dismissed a challenge on technical grounds, while also noting that it raised serious questions. And lawyers opposing the citizenship law are challenging the bylaw under Section 15 of the Charter, which of course guarantees the right to equality, and Canoe Lake's leadership is defending it, citing last year's Supreme Court of Canada decision called Dickson versus Vuntut Gwitchin First Nation. So I'll just give a brief refresher on what Dickson was all about. And this was a case that the CCF intervened in at the Supreme Court level. So Cindy Dickson was a member of the Vuntut Gwitchin Nation up in the Yukon. She wished to stand for election as a band counselor. She has a child with a medical condition, which necessitates that she have access to a hospital. So she lives in Whitehorse rather than Old Crow, which is the community on the settlement lands. And Vuntut Gwitchin concluded a self-government treaty with the Yukon provincial government in 1993. It has its own constitution, and in that constitution, it's created a rule requiring all band council members reside in Old Crow or move there within 14 days of being elected. And Dickson couldn't do that, as she asserted that this rule was a violation of her right to equality under Section 15(1) of the Charter. The Indigenous government, the nation, of course, responded that she was prevented from even raising the charter against its own internal constitution. And in the result, a majority, 7 judges of the Supreme Court upheld the residency requirement. They upheld it, finding that it was irreconcilable with the Charter's equality guarantees. So effectively, that particular distinction, because they also said it went to the core of Indigenous practice, the connection to the land, etc. It was beyond the Charter's reach. And at the time, I wrote in the Hub, this is about a year ago, it's too early to be sure how this complex decision will play out, because there was a lot of hedging. They weren't saying that the charter never applied. They were just saying basically when push come to shove and there was a true conflict, that Indigenous law could prevail over the charter. So I said it's too early to be sure how it will play out, but it may be bad news for Indigenous women. And I also referred to the dissent written by 2 female judges, including Justice Obonswim, who is the only Indigenous Supreme Court judge, would, in my view, have better reconciled the competing collective and individual rights. So Chief Francis Iron of Canoe Lake stated that, in his view, the Supreme Court ruling confirmed the nation's sovereignty to make laws to preserve our indigeneity. So I see what he was picking up on there. It's clever, because they do say if you are claiming that a law goes to the core of indigeneity, it's very hard to challenge it on charter grounds. And back to Dickson, Michelle Obonswin, she wrote that the charter applies to Indigenous governments because they have lawmaking authority, and that a First Nation is a government by nature and is accordingly entirely subject to the charter. And so look, I find this concerning. This is exactly the direction that I was afraid the Dickson precedent would go in, although the courts can still write it. So here's my case for why Justice Michelle Obonswin, our only female Indigenous Supreme Court judge, why we should follow her dicta here. Look, the Charter creates fundamental rights protections that should extend to all Canadians, including Indigenous people, in their interaction with their own nations. As Justice Obonswin stated, they have lawmaking authority, and a First Nation is governmental by nature. And this particular citizenship law goes beyond reasonable membership criteria or reasonable laws that could be shielded by invoking indigeneity. They actually enable potential discrimination of Indigenous people based on arbitrary assessments of character, trouble. These are all, terms from the citizenship law. Failure to adopt the way of life of the First Nation. What does that mean? These are very broad, they're very subjective, and they could allow leadership to exclude individuals for reasons that would clearly be in violation of Section 15. Indigenous people should not be forced to choose between their cultural identity and collective identity and basic rights protections. And in this law, we see that the most vulnerable members of the community, including adopted children, people with juvenile records, those who have perhaps disagreed with leadership, these are exactly the people that need the protections of the Charter in order to ensure fair treatment. And so, of course, Indigenous sovereignty must be respected, but no government power in this land can be absolute. The Charter can and should be applied in ways that respect Indigenous legal traditions, while acting as a backstop for abuses of the authority. Section 25 of the Charter specifically protects Aboriginal rights, and so this compromise between individual and collective rights was contemplated by the Charter right from the outset. And from my view, the principle of reconciliation is better served by ensuring that Indigenous people have access to both their cultural rights and individual protections rather than forcing them into some type of either or binary. So, Josh, I know that you also had your eyebrows raised when you looked at these Canoe Lake provisions. And right before we got on, you said that Dickson was a boring case from the Supreme Court. It was certainly very long, and this one was more interesting. But do you agree with me that this represents exactly the extension of Dickson that we were hoping would not come to pass?
Yeah, it does, because the test from Dickson is not very clear to me, even as a lawyer. And so, if you're like a layperson, how are you supposed to figure this stuff out when you're, writing a new citizenship law or voting on that type of law? It's just another area where we have an extremely long decision from the Supreme Court that doesn't give a lot of clarity. But I don't know. One of the reasons I found this interesting is just, knowing sort of a little bit about the politics that goes on in First Nations, which are often very small communities. You can see how this type of thing has would happen. You often have, one group in a First Nation that wants to, follow the rules and create like a safe and healthy, happy community. And then you'll have other groups that are not following those rules, and they make life really difficult for all the other people in the First Nation. So it's not surprising you have a group trying to, keep people out if they have sort of bad character and they're causing a lot of problems in the community. And as far as possible, that should be up to the local community to decide, right? Like who are we as people that don't live there to step in and say that. But this particular law sounds like it goes way too far in terms of allowing arbitrary power for some people to keep other people out, and that's not okay. And I can't really see how grounds of maturity and character, trouble, community dysfunction, or unrest, or other considerations could go to the core of indigeneity that we're talking about here. So I would imagine that this law isn't upheld. But yeah, it's a good reminder that the Charter matters for all Canadians, and Indigenous people, whether they like it or not, are Canadians in addition to being Indigenous. So it's a good reminder of why it was important for us to step in and make sure, or try to make sure, there aren't charter-free zones on First Nations, because this stuff does matter and it affects a lot of people. So,
Yeah.
okay, let's take a break, and when we come back, we'll do our bad legal takes of the week. Okay, I'll go first this week since Christine's away. So my bad legal take is really short. We had trouble narrowing this down and deciding which bad legal takes from the party leaders, because both Liberal leader Mark Carney and also Conservative leader Pierre Poilievre had some bad legal takes on the Constitution this week. But I decided the most important, the most consequential one is Carney's claim that he's not going to repeal Bill C-69, which is absolutely stunning, because his ads running on TV say "Build Canada," and he keeps talking about building pipelines. But Bill C-69 is probably the primary reason that we didn't build any pipelines, or I guess we expanded one, but we didn't actually build any new ones for the past 10 years. And that's because this Impact Assessment Act, which is this absurd woke law that tries to usurp all power to the federal government and give them a veto over every project based on concerns like whether the pipeline is, appropriate from a gender lens, or whether every single First Nation has been, properly consulted and had Indigenous ways of knowing applied, and just absurd environmental rules about the impact of the carbon emissions that no other country would even consider. Anyway, this is the whole reason that pipelines didn't get built, and the court said very clearly in a reference case that we intervened in that you can't do this. You can't take away all of this provincial jurisdiction. So the idea that Mr. Carney is not going to repeal this if he's prime minister in May is pretty crazy. As former Alberta Premier Jason Kenney wrote on Twitter, repealing the bill basically isn't optional. To quote Kenney, he says, Mr. Carney appears to be thumbing his nose at the courts and the Constitution. The Liberal Party can't claim to be defenders of the Constitution while flagrantly ignoring the Constitution. You can't criticize the Trump administration for threatening to ignore court rulings if you support the government in Canada in doing the same thing here. And I think that's right. Like, there were some amendments to C-69, but they didn't address what the court said in its reference case they need to address. And yes, it's a reference, so there wasn't a particular order to the government, but they're basically ignoring the Constitution if they don't repeal this bill and start from scratch. So that's my bad legal take. Like I said, we could have gone after Poilievre as well, but this was the most egregious one, I think. Joanna, what do you think? What's your bad legal take?
Okay, so my bad legal take goes to, I'm just checking what level of court this is, on Ontario's Superior Court judge that recently found that for the purposes of public nuisance, that education may be a legally viable right. So quick background, the Toronto District School Board filed a lawsuit against social media companies, including Meta and TikTok, claiming that the platforms are interfering with students' education. And TDSB is arguing that the social media products are so addictive and harmful to students' mental health, which in turn impacts their ability to learn effectively. And so they are advancing a suit in public nuisance. Now, traditionally, public nuisance claims address issues like blocking public roads, polluting waterways, physically preventing access to public services like healthcare facilities, and the court is considering whether this doctrine can be extended to include interference with education via social media. And to be clear, the Superior Court has not made a final ruling on the merits yet. This was a preliminary motion called a Rule 21 motion, where the social media companies tried to have the case dismissed as having no reasonable chance of success. But the judge denied this motion, ruling that it is not plain and obvious that the TDSB's claim will fail, so it should proceed to trial. And so, of course, I understand the concerns about social media's impact on education, but this application of public nuisance law is a wildly inappropriate extension of the doctrine for a few reasons. First, public nuisance, as I mentioned, has since historically been linked to tangible physical interferences. And so the court is extending a doctrine totally out of context. And then second, if we're going to play so loosey-goosey with public nuisance, we're going to turn it into a catch-all for any conceivable societal problem. And the platforms at this hearing argued that this could allow nuisance law to devour the entire law of tort, create unpredictable liability for virtually any type of product or service. And the court frames this as simply applying old law to new facts, but it's really clearly creating new rights. And if we want to have a mechanism for dealing with this type of claim, clearly the legislative process would be much more appropriate. So bad legal take, reading in a right to education so that it's a catch-all for any possible thing that can be claimed. And the TDSB, rather than trying to refit public nuisance law, should just tighten up its own policies about devices, I would think.
Yeah, just crazy, Joanna. So there's proximity between social media companies and the Toronto District School Board, but there's no proximity between Health Canada that forced people to get vaccine and the people forced to get vaccines. Got it. Okay, makes a
Yeah.
lot of sense. That's the end of the show. We hope you'll rate us, review us, and subscribe. The CCF is a nonpartisan charity funded by your donations, so please do click the donate button on our website if you can. Thanks for listening.